For 3 consecutive times, Sambo Dasuki was arrested, detained and charged before 3 different courts, and at each time the Nigerian courts found him deserving of bail. His last release from the Kuje prison in December was the most short-lived since his first arrest in July 2015. He was picked up few minutes later and has been in detention ever since, based on anticipatory charges which the government has yet to file. Dasuki's challenge of his continued detention had been rebuffed by a Nigerian court on grounds that it did not infringe on the multiple bails earlier granted him. The Ecowas Community Court of Justice appeared to be the only option of redress left, and the court presided by Justice Friday Nwoke and 2 other judges ruled Tuesday in his favor after dismissing a challenge to his jurisdiction as raised by the Nigerian government. Referring particularly to Article 6 of the African Charter and Article 9 Sub 1 of the International Convention on Civil and Political Rights, the Ecowas Community Court asserted that no Ecowas citizen shall be deprived of his freedom except for reasons expressly stated under the law. The court insisted that the reasons stated by the Nigerian government that Dasuki's detention for the past 10 months was due to ongoing investigation was unknown to law and against the principles of natural justice. The court also reminded the Nigerian government that it is a democracy and the rule of law must prevail to safeguard against executive arbitrariness, which not only is an encroachment of the judicial powers, but emboldens executive agencies to act recklessly. The Nigerian government was also reminded that it is a signatory to international human rights treaties, and however grave an offense is, it is bound by international protocols, and due process must apply, as preventive detention should be cautionary, not punitive. It observed that Dasuki should have been charged to court, and his prolonged detention on suspicion of committing an offense is a clear violation of domestic and international law and treaties. The Ecowas court therefore ordered Dasuki's immediate release and the release of his properties, having invalidated the search warrant on his Sokoto and Abuja residence as lacking in authenticity for not being duly certified. The challenge, however, is how to ensure the judgment is complied with.
The next big question is how the Nigerian government will respond to the judgment just delivered by the Ecowas court. And it's quite interesting because Nigeria, out of the 15 member states of the Ecowas, is the only country to have set up a national authority for the enforcement of Ecowas court's decision. About 25 decisions are yet pending for enforcement by about 14 states within the Ecowas sub-region, a major challenge for the Ecowas court to really find its footing within the sub-region.
Dasuki's lawyer is hopeful that the Buhari government will enforce the judgment.
No, we believe they are going to comply because it's the right thing to do. And this is the highest court in this continent, in this West African sub-region, when it has to do with the issue of human rights. So we have no doubt. They have been playing a whole lot of role at the ECOWAS sub-region. So we have no doubt that the president will honor this judgment and release our client promptly.
The lawyer for the Nigerian government was not available for comment as he could not be found after the judgment was delivered. Utabel Moran, AIT News, Abuja.